hopefully I can provide y'all with some information on how to best structure your business and how to avoid a lot of the common pitfalls as far as reasons people come to see me to get their business out of trouble that they got into. So we're going to start out with the bad. I have 13 legal pitfalls that we're going to talk about to avoid, and then we're going to kind of recap with the 7 steps for success, because we have 13 bad and 7 good. So the flyer that you're getting right now are the 7 positives, which a lot of it's an overlap, but we're going to start out with the bad because that's really what you're all here for, is to find out, you know, what to do to avoid having to deal with lawyers after you incorporate and after you set up all of your documents, right? So if you have questions, and I'm real informal, if y'all have questions during the presentation, just stick your hand up and I'll you know, ask you to state the question. I'll repeat the question so that everybody can hear it, and then I'll do my best to answer it, and we'll go from there. So the legal pitfalls in your business, unfortunately, every business is going to face a challenge, and a lot of times those challenges are when the business is you know, going through temporary problems and not making money, but other times the problem that the business faces is when it's at its peak, when it's making the most money. Now, why would a business be having problems when it's making money? Well, it could be that there's partners that are fighting. It could be that there's you know, disputes over you know, how to distribute assets, how to get to the next step in terms of you know, in terms of business growth. So there's all kinds of reasons. So you can't assume that the problems that the business are going to have is from the business failing. It could be actually just the reverse. So what we really need to talk about, I understand y'all, a lot of you are in the process of incorporating. Let me just see by a show of hands, how many of you have actually either incorporated or set up your business as an LLC so far? Okay, that's good, that's good. The rest of you, we're going to talk about different structures, whether you should be a corporation. If you're a corporation, should you go S Corp? If you're an LLC, why are you an LLC, and how can we best make sure that your LLC structure is the best? So we're gonna start out really by talking about that. But I mean, the main thing that you could do wrong is from the get-go is choosing the wrong corporate entity. And it sounds boring. This isn't, you know, as exciting as crowdfunding, but unfortunately, it's really the first thing you need to do is make sure your business is set up properly. So there's several different ways that you can set up a business. There's a corporation, which your corporation could be if you don't do anything and you set up as a corporation, you're considered a C Corp. What that means is a C Corp is required to file a separate tax return, and you don't get that flow-through benefit that you do if you make the S Corp election. The S Corp election is basically, it gives you some tax advantages, especially if you're a family-owned business, if you don't anticipate bringing in foreign investors, if you don't anticipate going public, and you want to kind of keep it close to home, like a mom and pop business or a sole proprietor business is usually best suited to be an S Corp or corporation. Different structures are for different opportunities and restrictions. Changing your structure later on, is it impossible? No, of course not. Businesses change their structure all the time. But you have an advantage not only for operating your business, but also for personal liability reasons, as well as for, you know, when you choose to fund your business, if you're set up from the get-go with the right corporate structure or LLC structure. It's just a lot less painful administratively and easier if you do it right the first time. So of course I'm going to say, you know, you probably want to use the information that I give you today, but also feel free to call me or contact, you know, the resources that you have here to really, you know, make sure that your business is structured properly through a legal sense as well as through a taxation sense. I'm not a tax attorney, I'm not a CPA, so, you know, the advice I give you today on how to structure whether you should be an LLC or whether a corporation, I would also encourage you to run it by a CPA and just make sure that you're going to be okay from a tax standpoint as well. So, you know, LLC, basically, the advantage of an LLC is, and Mr. Tanner's going to be speaking to you a little bit later, and him and I have talked about this. One of the advantages that someone will choose an LLC is that it's a little less work in terms of, you know, operating, as far as you don't have to have an annual meeting, you don't have to keep minutes. There's a lot of the rules that a corporation has to follow that an LLC doesn't have to follow. But Jim said, I'm going to try to talk you out of having an LLC, and the reason why is if you're a sole member, if you're the only person that's involved in your business, and you're choosing an LLC structure, you need to say, why are you choosing yourself as an LLC? Is it because you went on LegalZoom and LegalZoom said to do it? Is it because somebody else did it and it sounds cool? You know, it does sound cool. LLCs are like the cool kid on the block, but the negative to an LLC, there's two really big problems with an LLC. Biggest one is IRS. If you're the only person, if you're the only member in an LLC, the IRS ignores your entity. It considers you a sole proprietor, so you get no tax benefit whatsoever, and that's huge. Second reason is if you're a single member LLC, yes, the revised LLC Act is in Florida, it's alive and well, and yes, there's all these wonderful laws that say you've got that corporate shield, but the bottom line is there's still a little bit of a stigma with a single member LLC compared to a corporation which has that, you know, that shield, which yes, the shield can be pierced, but we're going to talk about different ways that you can protect your business from personal liability. But really, I guess, if you get anything out of this first legal pitfall, it's making sure that if you do choose to be an LLC, you're doing it for the right reasons, and not just because it sounds cool. Make sense? Any questions so far? Okay. The second thing you could do wrong is now you've got your corporation set up, or you've got your LLC set up, and you say, okay, great, we're an entity, we're on SunBiz, and we exist, and you go and you open your bank account, and you've got a couple partners, and everything is great. Well, that's wonderful, but if you don't have an operating agreement, or if you don't have, if you're a corporation, you need a shareholder agreement. And those agreements are really critical, because you need to make sure, just like, you know, I hate to say it, but it's kind of, think of it like a prenuptial agreement for your business. Hopefully nothing will ever go wrong, but even if you and your partners love each other throughout the business life, something could happen to one of your partners, and now you're dealing with, you know, his heirs. Or, you know, let's say he goes bankrupt, and now you've got a problem. Let's say, you know, somebody gets sick and they want to withdraw from the partnership or from the LLC. If you don't have something in writing that, you know, to anticipate these things that most business owners a lot of times don't anticipate, you get yourself in a world of hurt. And again, this goes back to kind of the preface where I said, if things are going badly, that's when everybody's going to, you know, really want to, you know, blame each other. You see finger pointing. You know, he went bankrupt. Well, he got us sued. He signed that contract. We don't want to do that. But it's also equally important, you know, when Mr. Tanner comes in later and he talks about crowdfunding. If your ship is not put together properly, if your ducks are not in a row, nobody's going to loan you a penny. It's not going to happen. You need to make sure you have those operating agreements, and they really need to be drafted properly. That's really important. The third thing that can be a legal pitfall is not keeping proper company records. So I mentioned briefly piercing the corporate veil. You can have a business and you can have a corporate entity, and it could be ABC Corp, and John Doe is the main shareholder underneath it, but if you're doing things that, you know, if you're not keeping proper company records, if you're not keeping, you know, proper business records, it could be very easy if you do get sued for that creditor to come back and say, that's not a real company, that's just bogus, and I'm going to sue you personally because you didn't do X, Y, Z right. So, I mean, there's a lot of examples for that. You know, keeping corporate minutes is one if you're a corporation. Even if you're an LLC, even if you're a single member LLC and you want to have that protection from your personal liability, you know, you need to make sure that, you know, you don't, and I'll get into this is actually the fourth one that we'll get into, is keeping your business accounts separate from your personal accounts. And that's really huge. You know, if you get yourself in a habit, it's really easy right now because you've got a brand new business that you're starting. It's really easy to get in the right habits of having your business account and having your personal account. You need money, you pay yourself a draw, you pay yourself a salary, however you choose to pay yourself. Obviously get tax advice on how to do that, but don't just simply pay personal expenses out of your business account. It's real important because if you ever do get in trouble and a creditor sees that you've commingled your accounts, or, you know, unfortunately, you see up there, I do bankruptcy. Bankruptcy is really my bread and butter in my firm. So if you have to file a personal bankruptcy and you're trying to protect your business, and you've got all this, you know, these transactions that blur the lines between what's business and what's personal, you're going to be in a world of hurt. Your business is exposed, and as well, by the same token, if your business needs to file a bankruptcy, your personal assets could be exposed as well. So it's not good stuff. So that's kind of the fourth pitfall that we're going to try to avoid. Using someone else's trade name, and Chris is going to get into intellectual property a little bit later, but you want to make sure, just like we're going to talk about protecting your intellectual property rights and securing your trademarks and copyright and all that. You want to, before you even go there, before you even develop assets that become your intellectual property, you want to make sure you're not taking someone else's intellectual property. You want to make sure you're not using somebody else's trade names. And this is multifaceted. This is really a thing that can hit home with a lot of you. Someone had asked me earlier about violating non-competes and trade secrets. If you hire employees, you want to make sure that you ask them, are you under any sort of non-disclosure? Are you under any sort of non-compete? And you document your file so that if you're bringing on people from other businesses and they're under some sort of non-compete or they're under some sort of non-disclosure, that you have in writing they're absolving your company from that, because otherwise, if they go out and they're playing games and bringing these trade secrets to your company, there's exposure for you. And I've had a lot of cases like that where I represented the business owner and they've got somebody that's really just playing games and getting them in trouble, and now we've got multifaceted issues. Now we need to protect the business, we need to use corporate bail, plus we need to defend the actual lawsuit. So yes, ma'am, you have a question? Yes, that's a great question. The question is, if you're under a non-compete, you've signed a non-compete agreement, but you have this great idea and you really feel stifled by it, you want to go to another company, but you don't want to violate your non-compete, so you want to pass that information on to somebody else who would serve as your proxy to go to that company and basically exploit that compete. You definitely can't do that, because most likely, without reading what you sign, most likely you sign something that says you can't do exactly that. You can't cause that information to be disseminated. You can't do it indirectly, you can't do it directly. Unfortunately, you're not the first one that thought of that, and it's something where it gets you over. Well, that's a great question. How would anybody find out? How would anybody find out? What they do is they would hire a lawyer, and they'd pay the lawyer a lot of money, and then they'd sue you, and then you'd hire a lawyer, and then you'd pay the lawyer a lot of money, and then we go through a process, and this process is called discovery. And through the discovery process, they would discover. They would make you provide all of your emails back and forth that you've ever sent. They make you. This person that is the proxy. They do a deposition. A deposition is where you have to answer questions under oath. They go to trial. And even if there's no evidence at trial, you could still lose, and you could still get a judgment against you if the judge believes them over you, and it could cost you a ton of money. So my advice is, honor the terms of a written agreement. If you sign a written agreement, it's not worth the risk. If you do get in trouble, it costs you a lot in terms of legal fees. Yes, sir.
So in regards to the trade secrets themselves, what classifies a trade secret? Because I guess the second part was I recently signed one that said the trade secrets themselves had to be labeled as trade secrets on the documentation, or been expressively stated to you.
That's a great question. What constitutes a trade secret? Trade secret has a lot of different definitions. The actual definition is going to be based on how it's defined in the agreement that you signed. And if there's language in there, like you said, that a trade secret has to be labeled as a trade secret, then that's great, because anything that doesn't meet that exact definition is not a trade secret. Assuming your employer is the one that drafted that agreement, it'll be construed against the employer. So that's great if it's defined that way. Most trade secret clauses, usually they'll define a trade secret as information, data, things that are not discoverable through the normal course of business by an outsider, things that are revealed in confidence. Source code is often a trade secret, customer lists, special processes, things that are being developed that are not yet patented, that sort of thing. Those are all trade secrets. But usually the trade secret clause in the agreements that we draft is 3 or 4 pages long, and it's pretty comprehensive. Yes, sir.
You mentioned that source code can be a trade secret. So if someone creates a mobile application or a website, the source code for that can be trademarked?
The question is whether source code can be trademarked. Yes. You know, it's difficult to really trade, and this is going to be more Mr. Tanner's, you know, you want to ask him as far as trademark protection for source code. It's more of it's my understanding it's more of a copyright, but big picture on who owns the source code is really what the employment agreement says. Or if you've got a work for hire agreement, and if your work for hire agreement says that the source code belongs to the employer, and it's work for hire, then it's clear cut. And I would encourage all of you, before you go and put time and effort into developing source code, one way or another, you make sure you have a written agreement, so that's important.
So it's like when we hire so it's as if we hired a company to create our product, and they make a sign saying like, after you give us payment, then you can legally have our source code. But until we get the payment, we legally have all control.
Yeah, the clause you're describing, in the agreement, you're hiring an outside company to develop your source code, and their agreement says that the source code only reverts back to you as work for hire once they're paid. Now, the problem you have with an agreement like that, and by the way, a clause like that is negotiable, but the problem you have with a clause like that is if you're not satisfied with their work and you don't want to pay them, and then you get into court, they can hold your source code for ransom, and you end up having to pay somebody else to do everything from the beginning. And again, those are the sorts of cases I deal with in my civil litigation firm. We go to court a lot on issues on who owns what and who did what, and you know, people that don't want to pay, people that want to take advantage of others. So you know, big picture, you know, we're on number 5, but basically it's I mean, we do have a lot of material I want to cover, but basically big picture is get it in writing. I mean, that's really what this is all about. Not only get things in writing, but make sure you understand what you're signing. Make sure your agreements are not just some boilerplate that you got on LegalZoom, but something that actually fits the needs of your business. Because remember, a lot of these agreements, like for example, a work for hire agreement, that might be drafted on behalf of an independent contractor rather than the company. If it's your company, you want to make sure it's drafted for your benefit. So the name of the game is always try to draft the agreements if you have control of that process. We talked about commingling accounts, bank accounts. Make sure not only that your business accounts are labeled as business accounts, but also that they're only used for business purposes. You don't want to use them for personal expenses. Failing to protect intellectual property, and again, Mr. Tanner's going to get into this a little bit, but you want to make sure that, without really getting into how to apply for a patent and all that, you want to make sure early on in the process, if you're meeting with investors or if you're meeting with prospective partners, you do have them sign a non-disclosure agreement, and those agreements, you can find templates anywhere. I mean, if you need to, get my blessing on it, feel free. My information is in that handout. But basically, you want to make sure you're protected from just giving away all of your information to somebody that's going to go out and just copy it. The reality of the situation is, and Jim and I have talked about this, most people don't do that, especially especially investors, and especially they're not really interested in that. They're interested in whether they're going to invest, not like how to steal, but just with that being said, it doesn't hurt to be cautious in terms of how to make sure that you're protected from somebody taking your property. Number 7 legal pitfall that you can avoid easily is by failing to have adequate employee agreements. And it's no less important than having the founders agreements. We talked about having an operating agreement and a shareholder agreement if you're a corporation. Having employee agreements is it's really important. It's important for a lot of reasons. It's important from a legal sense because you want to make sure that your employees don't steal from you, or that you don't get sued, or if they're independent contractors, you want to make sure that that they're not expecting you to withhold taxes, and that the IRS doesn't commit. I mean, all the obvious reasons why you want to make sure that you have employment agreements. But the other non-obvious reason that you want to make sure that you have an employment agreement is because if you want to grow your business and you want to expand it and you want to duplicate it, make it something that's scalable, you want to have an employment agreement with everybody that's in this, in your business. And there's an excellent book I would really encourage you all to get, E-Myth. Has anybody read the E-Myth? It's great. You know, at the end of it, you know, the founders of this business, what they do is they sit down in a brainstorming session, and there's 2 of them. And what they do is they determine that there's 15 different jobs in the business. Payroll job, you know, selling the pizza job, all these different jobs. And they assign those jobs to each other, and they create employment agreements for the job, not for each other. You don't look at like, you know, well, Bob's doing that, let's make an agreement for Bob. You make it for the position. And you should do that for every position in your business. And that does several things. It's great in a legal sense. It's when you go to fill those positions. It may just be you in your business for the next couple of years, but you might have 15 jobs. So how many people think they should have an employment agreement with themselves and their business for 15 different jobs, even if they're the only one in the business? Yeah. Because those jobs are not always going to be just you. And if your business is going to grow and you're going to scale your business and you're going to make it into something that can easily be duplicated without you, you need to do that. So failing to have employment agreements across the board is a bad idea. It's you know, something where you want to just make sure that you know, that you've got that in there. And going along with trade secrets and all that, you want to make sure that any employee that comes to work for you signs, they have a clause in your employment agreement that says that they're not under any sort of non-compete. So that way, that's a defense. If you find out later, you know, you get served, you got some sort of non-compete lawsuit, you could say, well, look, I asked them and I've got this and this is my defense, and that might help you out. So, you know, I mean, you're not required to like call the prior employer and add, I mean, you don't want to, but you do need to make sure you've got something, and you need to make a reasonable inquiry to the employee that you're bringing on, as far as you know, what the extent of that non-compete is. Ask to see it, read it, have an attorney review it, you know, talk about what that employee is going to be doing for your business, get the facts, and make sure that you're not going to be in any sort of trouble by bringing that employee on and having them go to work for you. The 8th legal pitfall is failing to comply with federal or state securities laws. And you know, Chris is going to be talking about crowdfunding a little bit later. He's here, and you know, we're going to talk about how to raise money, which is the exciting part. I know this is boring. Everybody's waiting on that, but you know, but I'm not a securities attorney, but I can tell you, if you raise money the wrong way, even under the new laws, you know, they revised the laws as far as you know, what's an accredited investor, how to disclose. All that's been totally revamped over the last couple of years. But the bottom line is, it's still something you need to watch out for. You don't want to sell securities even to friends and family without some sort of, you know, compliance with that law. You want to make sure that you know, that you do things right. And the best way to do that is really make sure that before any money changes hands, before any stocks are assigned, before any membership interest or assigned, that you just meet with an attorney. And there's resources here. You know, we're all here to help you. You know, we'd rather see things, you know, get off right, and then, you know, not have to have you come back and maybe being sued. Although if that does happen, we're here. So, the 9th legal pitfall: failing to properly execute contracts. And you know, companies sometimes fail to properly execute a contract. And this is, I've got a case right now where this is a huge issue. It's a Chapter 11 case, bankruptcy case, and it's like a life or death issue for my client. And it comes down to how something is signed. The correct way, and if you're all taking notes, unfortunately I don't have this in my 2-page flyer because it's short. But the correct way, if you're intending to bind your company, and your company is XYZ Company LLC. The way you bind your company is you sign, your name is Jane Smith, you sign by Jane Smith, its president or its managing member, as an LLC would have a managing member. You sign your name, you make sure that the full name of the entity as it's registered, you don't just say XYZ Company, you don't just say XYZ, you don't just say, you know, Bob's Hot Dogs. You take the full entity as it's registered on Sundays, and then you say you sign your name, and then you sign whatever your position is that has the authority to bind the company. You make sure you do have the authority to bind the company. If you're, you know, if there's a bunch of people that are involved in your business, you want to make sure your articles of incorporation or your operating agreement allow you to bind the company. Otherwise, you could potentially have personal liability as well. So making sure you're binding the company properly is very important. The wrong way to do it is just you know, you're in a hurry and you get some sort of vendor contract and you're all excited and you got this great contract and they draft it and they just, you know, there's just a signature line, there's no corporate block, and it's just a signature line and you're so excited about it and you just sign your name and you forget about it. Now you're personally liable. Your company is not bound by that contract. You are. That could work for you or against you. Most of the time it works against you personally. Most of the time what happens is business goes south and somebody comes by and tries to sue you personally. But in my case, it's the opposite. My client had intended to bind his business, and instead he only bound himself personally, and it's a real problem. I don't want to get into the details on Chapter 11 bankruptcy and why it's a nightmare. But bottom line is, it's you know, if you don't sign your name the right way, it's a mess. Are there any questions about that? Does anybody have any questions on how to sign your name to bind the company or how to not bind the company? Yes, sir. In the shirt.
Are you talking about just like any contract that you go into an agreement with, or are you talking about certain situations?
Sure. The question is, does this hold true for any contract or just certain situations? I consider any contract a legal contract. If I sign, you know, a $5 credit card receipt, it's a legally binding contract. Now, do I really write out a corporate block each time? No. But for real legal contracts, you know, and that could be really, I'd say, get yourself in the habit of doing that for everything across the board. You know, while you're first starting out, so that you get used to doing that. And if people say, "What are you doing all that for?" Just say, "My lawyer said so." She's weird, you know, humor. It'll pay off in the long run. There's some other questions. Yes, ma'am.
You said sign your name and the company name?
No, you should. What you do is you put the company name. You write the company name out on top, and then you say "by," and then you have a line, and then you sign your name on the line, and then underneath that or right after that, you put your corporate status, president, if it's an LLC, managing member, whatever your authority is to sign that contract. Any other questions on that? Yes, ma'am.
For a DBA, if I have a DBA as a part of my LLC, and I'm signing the contract, so I would also include the DBA name as well.
That's a good question. Yes, the question is, you have an LLC which owns a DBA. Do you include the DBA? You list, if you intend to bind the company in the DBA, you list the company under the company block exactly as it appears on Sunbiz. So you'd say ABC LLC DBA as whatever your DBA is. Treat that, use that as that's like your business name. You're going to use that entire thing, including the DBA, for everything. Anytime your business is anytime you sign a lease, anytime you open a bank account, anything formal, you want to make sure that you use that entire thing. Number 10 way you can get in trouble is signing a personal guarantee. The primary reason that you go and you incorporate, the reason we set up a separate entity is part of it is to create a separate entity that can be sold, passed on to heirs, sold to investors, you can raise money for it, all those things, you breathe life into it, you make it a separate entity. But the other main reason that people will do that, even if they have no intention of doing any of those things, is to shield themselves from personal liability. So why would anyone, after going through all the effort of setting up a corporation, why would they sign a personal guarantee for any business? Can anybody know why they would do that?
They want to get sued.
Why would someone, wanting to get sued? But also there's more practical reasons. Yes, sir, in the white shirt.
Company doesn't have a credit history.
Somebody might sign a personal guarantee because the company does not have a credit history. And yes, that's the big thing. All of your, when you get business credit cards, all of your business credit cards will most likely have a personal guarantee clause. And if your business defaults, they will most likely come after you personally. Some credit cards will report directly on your personal credit. Others, like American Express, will only really do anything to you personally if you default. But the bottom line is most creditors will not extend credit to a business entity that has not yet proven itself. If you go to sign a lease for commercial space, about 90% of the time the landlord will require a personal guarantee. And personal guarantees, everybody know what a personal guarantee is? Basically it just means that your business is on the lease or on the debt, but you sign guaranteeing where you will pay only if your business fails to make the payment. Doesn't mean you're on the hook immediately. They're not going to start sending you bills. It's not going to go on your personal credit. If your business defaults, they can immediately come after you personally without having to pierce the corporate veil or any of that other stuff. So that's what a personal guarantee is in a nutshell. They're usually, a lot of times they're found in small print. With most commercial leases though, when you sign a commercial lease, usually it's above board. It's usually not some sneaky thing. It's usually discussed with the landlord ahead of time. And in fact, it's very negotiable. Let's say you're signing a 5-year lease on commercial property and the landlord wants a personal guarantee. You can negotiate with the landlord on that. You could say, for example, you'll give a personal guarantee, but only for the first 2 years. And that's all negotiable. A lot of people don't know that. They think it's all or nothing, but you can definitely negotiate that. Personal guarantee clauses are not always very conspicuous. A lot of times, you don't see it until afterwards, and then you go to a lawyer to file a business bankruptcy, and they say, well, what about your personal assets? Well, what do you mean? Well, there's this. You know, it's very common to have a personal guarantee. They're not a mandatory condition of the transaction, but they're pretty common in credit card applications. Some vendor agreements. I mean, it really depends on the individual business that you have and how it works. But it's most common, the way we see it most in our practice is on leases and in lines of credit and credit card applications. Any questions on that? Okay. The 11th, this is the 11th, and again, we're going to go through, there's 13 pitfalls, and then there's 7 steps to success, and that's kind of the good news, and there's going to be a little bit of overlap, and then I'll have time for general questions. But, the 11th legal pitfall is overly relying on non-compete agreements. And, non-compete agreement is basically a contract that limits employees' abilities to compete with the employer. Such agreements are commonly used as an attempt to prevent employees from absconding with trade secrets. And when we talked about this, really, the goal of the prior employer is to really protect their business and use it to keep somebody from taking trade secrets. So there's a difference between a non-disclosure agreement that only protects trade secrets and a strict non-compete. A non-disclosure that protects trade secrets will be enforced for a longer period of time and more liberally than a strict non-compete that just says I can't work for a competitor. As a general rule, non-compete has to be, not as a general rule, the law is a non-compete has to be limited in geography and in time. And there's no hard, fast rule, but Florida courts usually, if you look at like the 2-year ballpark for time, geography gets a lot harder because a lot of people are involved in businesses that are done on the internet, they're done, it used to be, say, like a 20-mile radius, 15-mile radius is the ballpark. If you're in a business that doesn't operate like that, if you have a dry cleaner, if you have a pizza shop, that's one thing. But what if you have some sort of internet business that operates nationally or even internationally? Then the test for that is really, the courts, if it has to be enforced, they're looking at whether it's reasonable in scope. So I just negotiated a settlement with the client, in fact, today, where he has a business that he's in California and the other business is in Florida, but they do all this stuff on the internet. And there's really no way geographically to limit the non-compete. So what we do is we look at the nature of the industry that they're in, and we look at how to limit the industry so that they can each do what they need to do without any fear that these trade secrets are going to be absconded with and misused. So what do we really get out of this? It's non-competes as well as non-disclosures. If you ever do have to go to court to enforce it, the courts are going to be looking at whether it's reasonable restriction on whomever is the bad guy, person that's trying to be enforced against. And I can tell you, a non-compete that's longer than 2 years, that basically makes it very difficult for that employee to work anywhere in the industry, is most likely going to be considered an unreasonable restriction on their right to work. It's probably not going to be restricted. Now, it's really, they're designed as tools against unfair competition. They're not designed as weapons to keep people from being able to work in the workforce and get another job if they're terminated. So, they can be difficult to enforce, but the best advice I could give you is, yes, Mr. Tanner.
No, I got a question too, but that lady had a question before me. Yeah, go ahead.
Yes, ma'am.
With non-disclosure agreements, do you rarely see litigation enforced if an NDA is supposedly broken? And if you do, is it rare that you see someone creating a spin-off idea from a discussion they had on which the NDA was based?
Okay, the first question, and I'm going to ask you to repeat the second question after I go up first. But the first is this something really to worry about? Are non-compete agreements, non-disclosure agreements, is there real litigation over them? Absolutely, yeah, it's a real thing to worry about. You know, think about it. When you've got a business like your businesses, if all you've got is these trade secrets and all you've got is your you know, the thing that you want to bring to the next level and you're so close, and somebody goes out and tries to take that, that's a real thing. That is something you really need to worry about. A lot of the cases, most cases, just by definition, settle. But yeah, I mean, it's something where, you know, it is something legitimately to be worried about. If you have a specific concern, I can talk to you more about it later. But you know, but your second question, if you wouldn't mind repeating the second question with the spinoff.
Sure. Well, I think you essentially answered it in your first question, which, I mean, it was basically if in the NDA it specified that you cannot create a spin-off from the ideas that were discussed. So essentially a very vaguely related idea where you're trying to make revenue off of what you discussed and what the NDA was based on. Can that be enforced?
That's a great question. The question is, if you're under an NDA and you create a spin-off, what's considered a spin-off by the employer of the idea, because you can make the argument that it's not a spin-off. You could easily say this is something you created independent. That's a factual issue. That's going to be an issue where if it does go to court, it's going to be based on the evidence, and at some point, a judge or a jury is going to make a decision on whether it is a spin-off. And if it is a spin-off, then you're subject to liability. If you could prove that it's not a spin-off, but it's something that has, you know, totally unrelated, that's just part of your industry that you created on your own, then you'll win, and you might even be able to get your attorney's fees reimbursed. Yes, sir?
Derivative clause?
Yeah, derivative spin-off clause. Yeah, I mean, it's commonly found in these agreements, but it comes down to fact. I mean, like I could, Chris, you could probably give a better example as far as you know, intellectual property when you get into your presentation. But I mean, you know, the bottom line is it's gonna, all these things are gonna turn on what you can prove and what the facts are in terms of what is your, you know, whether this is something that you used, your employers hard-earned research and their money and their sources, and all you did was you just, you know, changed the name, or you changed Mickey Mouse and you changed the color of the shirt or something like that, versus creating something totally new that has, you know, really ingenuity that's unrelated. So yes, sir.
So what exactly classifies as spin-off?
That's a great question. I mean, that's kind of what I'm saying. We don't really. It's going to be something that would. What constitutes a spinoff is going to be basically where the company that's trying to enforce the agreement is saying, hey, that's a spinoff, and then you as the defendant saying, no, it's not a derivative, it's not this, I created it on my own. And you've got both sides going back and forth in court, and then a judge is going to say yes or no. And it comes, and the reason I can't answer it directly, I'm not being vague, it's because it's based on, like, you know, a couple years of litigation and getting all the facts as far as how it was created, you know, where it came from, whether there's, you know, new ingenuity. Chris, did you have any thoughts on that?
I do, and I don't want to hold up your presentation and distract from you. By the way, nice to see you. One of the things I want to bring up is when Mark Benioff established Salesforce.com and he broke away from Larry Ellison of Oracle. That was a quasi spin-off, but he went and got Larry Ellison's permission, and Larry Ellison had made it very clear that this is an area that we're just not interested in pursuing. Have at it. But the second part is you've been using the term spin-off a lot of these people in here may be wondering about it. That's not a recognized legal term, and if that's in the actual non-disclosure agreement or non-compete agreement, that's a problem, because that's not appropriate language, and I hope that we can find some better language. But my final question to you, regarding alienability of employment and moving from one job to another, Florida is trying to start to emulate and become more like California regarding employment law. And I'll just tell everybody in the room right now, this lady is a lot better at employment law than I am. I'm an intellectual attorney, intellectual property attorney. She knows a lot more about employment law. But one of the constraints and I would love to talk to you maybe later about this, I don't want to hold up your presentation, is how Florida can adjust their employment laws to be more like California. And I'll stop.
Sure, that's a great question. Thank you, Chris, for that. Yeah, I mean, basically, Florida's trying to be more competitive in terms of attracting businesses. We have the revised LLC Act, which is a huge help. I'm not going to really go into that today, but it really allows Florida to attract businesses that, up until recently were just, defaulting to California. I don't call myself an employment lawyer. I know enough just, to get through dealing with my clients, because I got a lot of clients that are reorganizing in Chapter 11 bankruptcy, and you have to know, a certain amount of thing. But yeah, you bring up a good point. I don't use the term spinoff. I wouldn't put that in agreement, but that's kind of, when we talk about derivative works, when we talk about all this, the terms of whatever you're signing are really going to dictate, what if you're going to be restricted, how you're going to be restricted, and all that. So, you really want to make sure from the employee standpoint that, and you bring up a great point, Chris. If you're in doubt, and there's two approaches to this, and this is really where it gets dangerous. You could ask for, in bankruptcy we call it a comfort order. You could go back to your employer and you could say, is it okay if I do this? And you can ask for permission. And you could get even something so much as a simple email saying, yeah, go ahead, is going to protect you from litigation later on. But how many people have heard, asking for permission versus asking for forgiveness? A lot of times, if you ask for permission, they're going to say no, and now you're like, okay, and now if you go and do it, now you've got definitive evidence in court that can be used against you that you knew you were doing something wrong. So you really want to be careful there. I'm not saying just go and do it and ask for forgiveness necessarily. That's really something that you have to kind of weigh if you're going to do something like this. At a minimum, get advice from an attorney before you do anything. That young lady, she's asking the right questions. I would encourage you to ask questions and not just go and say, oh, they're not going to sue me, don't worry about it, because they really do. A lot of these companies will sue you, and they'll be ruthless about it, and they'll do it to legitimately protect their business. They'll also do it to make an example for other employees. I see it every day. So you don't want to take it lightly. If you're on good terms with them and you think it's something, the other thing, along with asking for permission, ask for a comfort order, the other thing you could do is make it worth their while. Maybe give them a royalty or deal them in somehow. If I develop this and you acknowledge that it's not a violation of my agreement, and you sign off on that, I'll give you 5%. I'll give you whatever. That's a way where everybody wins, and I can't really, unless you're leaving on some sort of bad terms, I can't see that you're going to have a problem with that. So again, if you reach an agreement like that, you want to have more than just an email trail. You want to actually reduce it to a formal agreement if you reach some sort of agreement like that. Number 12, legal pitfall, and again, I'm not an employment attorney, but I know enough to say that it's a big problem if you overlook wage and hour issues. Does everybody know the general idea of the difference between an employee and an independent contractor? Have you all learned that? The IRS will consider somebody, they always want to say he's an employee. These employees. Why do they want to do that? Because they want money, they want taxes, they want to make sure that they get, the Social Security match. They want to make sure you withhold taxes. They want to make sure they get their taxes. They want their money, and that's all they care about. So they're always going to look to classify anybody that's doing any work for you as an employee if they can. So the way you want to make sure you do it is, yes, have an independent contractor agreement. And your independent contractor agreement is going to say, I'm an independent contractor, you're not withholding, and all this stuff. But the way you get yourself in a lot of trouble is the little things. I know a lot of people in the real estate industry, people that own real estate brokerages, and I've had friends that they've been gotten in trouble with the IRS because they've got the independent contractor agreement, and everybody knows. The agents can kind of come and go. They don't have set hours. They can do whatever they want. They have their own laptop. It sounds great. It sounds like, wow, they're really an independent contractor. But once a month, they have a mandatory sales meeting. Well, if you have a mandatory sales meeting where your contractors have to be there, and you're telling them they have to be there for a mandatory meeting, you could inadvertently, cause them to be considered employees. And how's that going to happen? Well, was the IRS going to sneak into your sales meeting? No, what will happen is You get an agent that gets mad at you for whatever reason. You get an independent sales rep that gets mad at you for whatever reason. They don't like their check. And all of a sudden they're here in this room and they hear this presentation. All you gotta do is call the IRS and rat you out, and now you've got a world of hurt. The last thing you want is to draw any attention to your company from the IRS. You know, pay your taxes, do everything you need to do it right, and stay under the radar and save yourself a world of hurt. Any general questions about that? Any questions about? And it's more involved than that. I mean, you know, the independent contractor test is. I think if you go on the IRS website, I think it's like 11 criteria. It has to do with, you know, who sets the hours, where does the individual work from, are they working from home, you know, what tools do they use, are they, you know, there's all these different tests, but you know, it's the little things that usually trip people up. It's you know, paying somebody a set amount instead of commission. And there's all different ways you could you know, really you know, get yourself in a situation where now you're required to not only pay, and this could be a real hard story, not only are you required to pay future future tax withholding and Social Security matching and all that for existing future employees, but you could be required to go back retroactively from the time that you've had these people working for you. And it could open up a major problem where I've seen businesses have to go under because of this sort of thing. Yes, ma'am?
Is it possible to have officers as independent contractors?
Is it possible to have officers as independent contractors? Yes, absolutely. The difference between the officers and the people that are actually doing work in the business, they're two separate categories. Your officers do not necessarily have to, you know, I mean, you're going to want to talk to your CPA. Once you start making money, officers are required to take distributions, and there's tax issues that you want to talk about. But as far as whether they're categorized as employees or independent contractors, it's really, you know, they're not required to be considered employees. If you're not drawing a salary, then you're not required to treat them as employees. But the problem, and again, this is real important, and this is a tax question. I'm just going to tell you enough that you need to, you know, run your CPA. If your business is making money, as an officer, your CPA is going to most likely tell you you're required to draw some level of salary. You can't just take money out, because that's going to get you in a lot of trouble. So how much salary and how much distributions, I don't know. It's based on how much you're making. It's based on your personal tax bracket and all that. But you know, just put on your to-do list. You know, once I start making money, get to CPA, find out how much of a salary I'm supposed to be. If you don't take a salary, the IRS will give you one. It's great. If you don't file a tax return, they'll do it for you. If you don't take a salary, they will give you one and they'll tax you for it. They do everything for you. It's really great. So you don't want to do that, because they're going to impute a salary on you and impute taxes on you that you may not even really be making. And how do they do that? They look at what your reasonable salary should be based on what your gross and net income is for your business. And then they'll just say, oh, you're the only officer, you should have paid yourself this amount. You didn't, but that's okay, because we're going to assume you did, and we're going to tax them at it. Great, isn't it? Yes, sir.
So for our product, we have multiple ambassadors that's going to be marketing our product for us. Would they be considered independent contractors, or can we consider them independent contractors?
You have ambassadors that are marketing your product for you. Are they independent contractors? It really depends. At the minimum, make sure you have an independent contractor agreement that says they're independent contractors. But again, the way you can really run afoul of the IRS is by saying one thing and doing another. So, you know, if the intention is that they're independent contractors and you're paying them on a commission or a per deal basis, you want to make sure that they have the flexibility to work on their own time, that you're not telling them mandatory hours or even things like having mandatory meetings. You know, you can have your meetings be voluntary. You could say, we're having a training session, we'd love you all to come. You know, those sorts of things are voluntary. But once you start requiring people to be at a certain place at a certain time for a length of time, you could all it takes is one mad ambassador that leaves and says, you know, I want to sue you for whatever, you know. So yeah, that could be a problem.
Are they required to get paid to be considered independent contractors?
I'm sorry?
Are they required to be paid or compensated with anything to be?
No, if your independent contractor agreement doesn't say, I mean, basically whatever your independent contractor agreement says, if it's all commission, then that's all you have to give them. You don't have to give them anything. You're not required by law to pay an independent contractor. There's minimum wages for employees, and that's a whole other ballgame, which I'm not going to get into. But if somebody is working strictly on commission, as long as you can prove that they're an independent contractor and not an employee, then no, you're not required to do anything for them. Yes, sir.
It's Samantha L. Hey guys, because of respect to time, I try and keep your Q&A related to the incorporation stuff, which has to be more incorporated, and you're going to be out of here at the end of the month. If you don't, just and let you have to get through the program. So if you have questions other than relating to entity, incorporation, that kind of thing, maybe grab Samantha afterwards or send her an email follow-up after the class. I think that's okay. Thanks.
Yeah, thanks, Jim. And I'm thrilled there's so many questions. This is great. You guys are really excited about your businesses and all that. My information is on here. Feel free to email's probably the best way to get a hold of me, but you can call me at my office as well. And if you have follow-up questions, you know, I mean, definitely I want to feel like you get as much out of this as you can. And, you know, you know, as far as the independent contractor, I could probably talk for hours about like independent. It's really hard. It's really hard to say, you know, whether somebody's an independent contractor. Yes, sir.
So do you believe the Uber drivers are independent contractors?
Are the Uber drivers independent contractors or are they employees? I don't know. I don't know the answer to that. I'd have to research it. But again, you know, if it were clear cut, I would know, right? I mean, it's not. Yeah, nobody, you know. But I want to move on because we do have some ground I have to cover. I don't want to cut into Mr. Tanner's presentation. So, thank you. But yeah, I mean, that's huge. That's a huge issue. If somebody is in the contractor or the employee, what do I have to do for them? Do I have to give them overtime? Do I have to reimburse them for expense? I mean, there's so many questions about all that. You know, the big picture is if they're considered employees, there's a whole bunch of stuff you have to do for them. If they're independent contractors, there's really not a whole lot you have to do other than honor the terms of your written agreement with them, or verbal agreement for that matter. That's another story. Not having a dissolution plan in writing is number 13, lucky number 13. One of the things that you can do that really is a legal pitfall is not knowing what's the future of your business. You know, your business is going great, you're going to live forever, your partner, you guys are all young, everybody's great, you know, it's going to be wonderful. But then, you know, what if something happens? And this goes back to number 1, which was not having an operating agreement, not having a shareholder agreement. When you incorporate, when you structure your business from the get-go, you want to make sure that your agreement says what you're going to do. Now, y'all have business plans?
Yes.
Yeah, most people have business plans. In business plan, you have an exit strategy, right? In your exit strategy, that's great, but you need to codify that in a legal document that's actually going to be binding on whomever is involved in your business. You don't have to put in there, we're going to sell in 2 years, we're going to do, you know, raise capital, whatever. But you need to put in there what happens if something really bad goes wrong. An LLC member goes into bankruptcy. You know, somebody dies. Do you want to be in business with the spouse as the heir? I mean, those are the sorts of things that happen all the time. Yes, ma'am.
So you recommend doing that right after you incorporate, at the very beginning?
Yes, that's a good question. When do you do a dissolution plan in writing? The best way to do that is really incorporate it into your operating agreement or shareholder agreement from the get-go. So the steps that you should do, first of all, decide how you want to structure your business. Take the information that I've given you today, call me, email me with additional questions. I'll help you really go through all the steps to make sure you're forming the right legal entity. And then what you want to do after that, after you think you know what you're going to do, is you're going to want to go to a CPA, and you're going to want to have that CPA, you know, weigh in on that. And you want to make sure. Now your CPA, just like you know, a lot of times, you know, a lot of these different programs out there will say, you know, you should be an LLC, go on LegalZoom. If you go on LegalZoom, and it says at the beginning of the page, it says, you know, pick the legal structure. You cannot get it. You put all your information in there, no matter what criteria you put in there, you cannot get it to say anything other than LLC is what you should be. You know, I tried it. I was bored one time on a Friday, and I spent like a half hour just going in there and put like, you know, we're going to have like one person and they're going to sell it. It still said LLC. It's just, it didn't matter what I put in there. So, you know, if you decide you want to be an LLC, make sure it's for the right reasons. Make sure you structure yourself right. After you determine what you're going to do, then you go on Sunbiz and you set it up. And I really should say this, you really don't need an attorney to go on Sundays and set it up. It's pretty easy. You know, by going on Sundays and incorporating and setting it up, there's several things that you're going to need to do. You're going to need to file your articles of incorporation. Assuming you're a corporate entity, that's what breathes life into your entity. That's what creates it. That's what makes it exist on paper. And that's done online. You don't need to fill out forms or anything. You go on Sundays. It's www.sundays.org. And you go in and you say, you know, file documents and create a for-profit corporation, for-profit Florida corporation. Or if you want to be an LLC, it's a for-profit Florida limited liability company. If you're non-for-profit, you just put non-for-profit. There's all these different categories. And then it'll prompt you. Go through the screens. While you're setting up the articles of incorporation, it's going to ask you who your incorporator is. Your incorporator is going to be you. Incorporator, once you're incorporated, it doesn't really mean anything. Incorporator is if you start the process and for whatever reason it doesn't fully get incorporated because you don't click submit, you know, and like whatever, and then you get sued. It's an archaic thing, you don't have to worry about it. So you put yourself as incorporator. What is important is in Florida, you need to have a registered agent. And your registered agent does not need to be an attorney, but it does need to be, if it's you need to make sure that you have an office that's open to the general public during normal business hours. And normal business hours is considered 9 to 5, Monday through Friday. You need to have it accessible so that if you get served with a lawsuit or if somebody needs to fine you, they can knock on the door and they can serve that registered agent. So, you know, most people will have their attorney that sets everything up for them act as their registered agent. You don't have to, you're not required to. Yes, sir?
What if you just use like your home address?
You can use your home address, but you need to make sure that I mean, technically, it needs to be, the law that I need to advise you is it needs to be an office that's open to the public. Do people do it with their home address? Yes. You know, but it's really more of a problem if you're operating outside of Florida. Because if you're here in Florida, they know where to find you. It's more, the registered agent becomes more of a problem for my clients that are in other states that need a registered agent to act here in Florida. So yes, you can list your home address on all your paperwork. You can list a PO box for everything except for the registered agent section. So you can have all your mail going to a PO box. You know, I'd say it doesn't. You don't want to do that. It doesn't really look professional. I mean, there's so many other ways you can get what looks like a real office address for the nominal amount nowadays. It's really don't want to, you know, use the post office box. But what happens after you submit? You pay your fee. It's like $70 plus the certificate of status. Or if you're going to be a LLC, it's $125. You submit that. And then about 2 or 3 days later, you'll get a email from the Department of Corporations, Division of Corporations, and it'll have your tracking number, it'll have your certificate of status. And that's when you're official. That's when your entity exists. Then what you do, the next step after you do that, after you have your entity, whether it's an LLC or a corporation, is you go on irs.gov, www.irs.gov. And even if you're not going to get any employees right away, you need to get a federal employee identification number. And it's really easy to do if you go to the IRS website. Now that you've got your corporate entity and it's all set up and exists, it's a living, breathing thing, you can apply for your EIN. Your EIN, they will ask for somebody's social security number. If it's just you, it's going to be your social security number. If it's you and a partner, you'll need to figure out which one of you is going to be tied to that entity for your social security number. And then basically you fill out the form. It's not very user friendly. You can't use special characters. You have to have your entity exactly as it appears. It take you about 20 minutes to fill out. And this is real important. This is going to sound silly, but when you click submit, when you're on your IRS site and you click submit, it's going to pop up and there's going to be a little number. It's going to be real small on the screen. You want to print that page out. You want to do a screenshot, print that page out, because that little number, you need to show that to your bank in order to open up a bank account. You show that and your certificate of status in order to show the bank account. Now, why do you have to do a print screen? Won't the IRS email you? Won't you get something in the mail? No, they won't email you, and if you exit out of that screen, it's gone forever. But they will send you a letter, but it'll take like 2 weeks to get it. So if you're in a hurry to go to the bank, you need to show the bank that print screen with your EIN number on it, otherwise you gotta wait till the IRS gets around to sending that letter. Yes, ma'am?
So you said you had to get rid of employees to
It's a federal employee identification number. If you go on the IRS site, their forms are difficult to find. The easiest way is when you go to their homepage, there's a search screen, there's a search thing. Just put in apply EIN and then click it, it'll send you right to the form. Otherwise, trying to find the forms can be difficult, but that's how I usually find it. But it's really easy and it's free and it's a simple process. There's another question. Yes, sir.
One of our partners is an F2 student. We know that we can't put him on the LLC as a member or a manager, so we put him on the operating agreement and gave him X amount of shares. Is that okay to do?
He is, I'm sorry, one of the members is what?
An F2 student
Oh, okay. One of the members is an F2 student and you have him,
on the operating agreement.
well, he can't be, I'm not aware that he can't be in an LLC. He can't be in a, oh, are you trying to be taxed as an S corp?
LLC.
Okay, but how are you taxed? Are you taxed as a, have you done an S corp election?
Yeah, corporation.
Okay, then if he's involved at all and you're trying to get the S corp election, you could disqualify yourself from getting that S corp election. I know you're an LLC, but even an LLC could elect to be taxed as an S corp. And yeah, you can mess everything up. So yeah, I mean that could come back to bite you later on. There might be maybe do some sort of other structure. I don't know. You could be taxed as a partnership. That's a CPA question. You want to get with your CPA before you do your taxes on that because that could be a problem.
Well, it wasn't really a tax question. It was really about because the F2 student they legally can't work in USA. They can't have being employed. So if they're part of the LLC, they're considered employed, right?
Well, that's one aspect of it. But again, I'm not an immigration employment attorney, but what I know is, the bigger problem that you have is that if you're electing S status for tax purposes, then if you have somebody that's a foreign resident as part of that structure, it could disqualify you from your tax. So I mean, it's an employment law question, which I don't know. I don't deal with that type of law, but it's also I know enough to know there's a tax issue there too. You probably want to get that checked out. Yes, ma'am. Unless you have a good reason, don't be an LLC. Yeah, I've quoted saying that. That's definitely one of my taglines. Some good reasons, and I was talking with Chris about this at another time, and he had given me some. Basically, with an LLC, you don't have to disclose your social security number. You don't have to deal with the IRS the same way. They're not as hard to manage. Like with the LLC, all you have is your operating agreement. And that's pretty much it. You don't have to have shareholder meetings. You don't have to keep minutes. You don't have to have a book of minutes. You don't have to do all the things that corporations legally are required by law to do. So I mean, those are some points. The other thing, and Chris is going to talk about financing and crowdfunding. And there's a significant school of thought that says basically if you're raising serious capital, they're going to want you to be an LLC. They're not going to want you to be a corporation. There's also another school of thought that says the opposite. So it really depends on what sort of investors you're going to be approaching. So one thing I can tell you with certainty is if you think you're really going to explode and you want to go and take your company public, you cannot be an S corp and go public. That's not, you can't do it. And trying to convert at that point is a mess. So that concludes my 13 pitfalls. I'm not going to go over the flyer too much because we're kind of out of time, and Mr. Tanner's going to talk about more exciting things. But this flyer, this has the 7 success stories, 7 things that you can do for success. Most of this is kind of the reverse of what I just talked about. It's kind of like this is what you should do, and the 13 are the things you shouldn't do. The only thing that's on here that's not on what I just covered is number 5 and number 7 on the back of this flyer. And basically, number 5, what you should do is you should partner with the right professionals. Don't be afraid to ask for help. Don't think you have to do everything on your own. Everybody has been there, where you are. Everybody's had failures. We walked in and, I couldn't help but notice, Henry Ford is a personal hero of mine. I love him. I mean, he built his business from scratch, and he had to file a bankruptcy because his models, before he got to the Model T, he was just, everything went up in flames. And he got through it, and basically, his theory was failure is just an opportunity to start again. And you walk by and see his picture and you think like that. And everybody has been at some level where they needed help, whether it be through the court system, whether it be through attorneys, whatever it is. And you want to partner with them. You want to have an attorney that's a general business attorney. You want to have somebody like Mr. Tanner that can handle intellectual property law, so that you have him as a resource before you need him, so that he can protect your rights. You want to make sure you have a CPA. And you really just want to make sure that you have these professionals before you need them, so that you're not scrambling trying to find an attorney whose office is a block away from the courthouse when you need them. So that's kind of what I'm going to end this with. Are there any other general questions? Yes, sir. The orange shirt.
Just have a question about as a small business, could I benefit from arbitration, and do I do that before I get sued or after I get sued?
The question is, should you have arbitration clauses in your contract? Will you benefit as a small business owner with an arbitration clause?
Or is it faster and cheaper?
Or is litigation cheaper? I don't know if you're asking, not so much asking the wrong person, but I'm not a big fan of arbitration clauses. I've seen them used more as a weapon from defendants that have done something wrong than I have seen them used to settle. I would say it's an alternative to arbitration. Mediation is much more, it's cooler. It's as cool as an LLC. It's plus it actually resolves things. Arbitration is generally, it's the costs are not really that much less in litigation, because when you go through arbitration, you still have to produce documents, you still have to present evidence, you still have to put on your case. Yes, it's less than usually a full-blown trial, but I routinely will advise my clients to strike arbitration clauses when we're negotiating contracts, because I'm not a fan of them at all. If there has to be some sort of alternate dispute resolution, I would say mediation is your better option. Yes, sir.
My question just has to do with, this states here you do real estate. Would you recommend commercial real estate being an S corp or an LLC?
The question is, should commercial real estate be an S corp or an LLC? By commercial real estate, do you mean a piece of property or?
Yeah, by a piece of property, just.
I would say neither. Again, I'll defer to your CPA on this, but if you have a single asset piece of real estate, usually you want to either put it in a trust or you want to set it up as an LLC, a single LLC. That's a good example of and that's from consulting with CPAs and tax people, so it's more of a tax reason, but from a privacy, personal liability aspect, trust is really the best bang for your buck. Yes, sir.
Can a verbal non-compete work?
No, verbal non-compete is not going to go anywhere. Yes, ma'am.
Would you recommend using an NDA when talking to potential investors and developers, and at what point in the discussion would that be necessary?
Do I recommend an NDA when talking to potential investors and who?
Developers.
And developers. Let's separate those. For potential developers, an NDA is really just industry standard. If you don't have one, you're saying, please take advantage of it. You want to have an NDA, you want to have it in place. Any developer that's reluctant to sign it, there's something not right. Now, when it comes to investors, that's a little bit different. Your investors are not sitting there saying, how can I steal? By pushing the NDA issue too much with a potential investor, it may not be your best move business-wise. I'm an attorney. I'm always going to say, have all these legal documents, and yes, you should have it. And I would say, yes, you present it. And you say, my attorney drafted this, she's weird, humor her, sign it. But if it becomes a real issue, it's going to stand in between you and your financing, or you and certain opportunities. Keep in mind, a lot of investors are funny. You don't want to defend them. And that's something maybe Jim can kind of weigh in on. But I'd say, you don't want to. They're not out to get you. They're not necessarily going to really go and try to steal your business model. So I would really have given like some sort of 20-page document signed in order to talk to you about their idea.
Let's take two more.
We're going to have two more questions. Yes, sir. Beck.
So I want to hear your thoughts on a buy and sell agreement. I've heard to some degree. So is between partners, where it's basically a clause that says the first person to really initiate the buyout of the other partner has the first right of refusal to that, and if they refuse, they have to buy out the other partner. So it's kind of like a trigger where if any partner at any time uses that, one of the two is getting out of business. And so if I try to buy you out, you have the right of first refusal, but then you have to buy me out if you say no.
Right, they call it a shotgun clause. That's common in buy-sell agreements. And basically, it does just that. It basically, the question is, you have a clause where if one partner, the first partner, does not exercise his right of first refusal and the second partner wants to buy out, then basically you've got it's business faces an insurmountable obstacle and you end up in court. It's pretty common. Without seeing your actual agreement, feel free to email it. I'd be happy to look at it for you. But but yeah, that's fairly common in those sorts.
Are there other types like that?
There's a lot of different types. There's many different ways we could draft it. So yeah, feel free to go with me afterwards. One more question. Yes,
as a new startup business, I have a question around the Dun and Bradstreet number. So I offer a service, and some of my clients find it beneficial for me to be a certified minority woman-owned business. And so that requires a Dun and Bradstreet number, but they also offer services. I just wanted your opinion around, is it beneficial to invest in the services that they offer?
the question is the value of Dun and Bradstreet and should we pay the money? As in your industry, as a small business, you're looking to get certain contracts, certain things that you wouldn't get if you did not have that number. All you're required to do is have that number.
Yes.
The rest of the services that they provide, I'm not going to, weigh in necessarily. I could tell you, you may want to, from a legal standpoint, none of them are legally required. None of that is really, it's not going to, unless you are, unless it's things that you want to buy. Like an example along the same lines is these companies that monitor your credit for you. They charge you $20 a month, and they tell you if this is before Credit Karma. Well, are you legally required to have a service like that? No, but is there value to it? For me, there was before Credit Karma. Now it's stupid, and I canceled it and I use Credit Karma. But at the time, as a new business owner, man, you may find that there's certain things that help you that they provide that are of value. But keep in mind that nothing on Dun and Bradstreet that they have is legally required by the IRS, the state of Florida, by any government entity. If certain vendors won't do business with you unless you have that magic credibility number, then you have to do it. That's a business decision, but it's not something that you're gonna get in any trouble. The other thing, and real quick, and I'll wrap up. After you go on Sunbiz and you do all that stuff, you're gonna get scams in the mail. And when you get stuff in the mail, remember, Samantha Dammer said, I might get this. And you're going to get scams, and they're going to say, if you want your certificate of whatever, blah, blah, you have to pay us $78, and it's going to look really official. You will really think it's from the state of Florida, and it's not. They're not going to send you anything for money afterwards. The only thing you're going to have to pay is in April of each year, you have to do your annual report. And that's whether you're an LLC or whether you're a corporation. Every April, you have to do an annual report. You have to pay a fee. They're not going to, if you get anything in the mail, and again, don't be afraid. We're all here to help you. If you get something you're not sure if it's real, email it to me, and I'm happy to take a look at it. And on that note, I thank you guys so much for the opportunity. If you have additional questions,
Thanks, Samantha. We'll take a break here in a couple of minutes.